Contracts and agreements sound similar, isn't it? But are all contracts agreement? All agreements are contracts. So this is the very question where many students feel stuck at. So in this video, we are going to cover what is the difference between an agreement and contract. So stay tuned to the last of this video so that you get understood what is the contract and agreement. So if you haven't watched the previous video on Indian Contract Act, where I have already covered the basic features relating to the Indian Contract Act. So now we will be understanding in depth regarding what Indian Contract is. So let's get started. So let us first have a quick recap on the introduction to the Indian Contract Act 1872. The Indian Contract Act 1872 is the primary legislation governing contracts in India. So it is the primary legislation governing contracts in India. So all kinds of contracts that we have will be governed under Indian Contract Act only. It came into force on 1st September 1972 and extended to the entire country. So this is the very beginning from where Indian Contract Act started. It is 1872 from 1st of September. Originally, the Act has 266 sections. So when for the first time it was enacted, it has 266 sections in total, which later, there are some differences or modification that made under this Act. Presently, only section 1 to 75, which deal with general principle of contract, are studied under contract 1. So all kind of general principle will be covered under contract 1 only, which will be describing what is contract, where the definition of contract falls under, what is the essentials, what are the necessities, what are the parties. So all kind of key features will be covering under the general principles. Section 76 to 123 related to sale of goods were later replaced by the Sale of Goods Act 1930. So previously all were, all were collabed together. Later we have given them special treatment. For example, the from 76 to 123, the sale of goods falls under the Sale of Goods Act 1930. Section 124 to 238 covers specific contracts like indemnity, guarantee, bailment, pledge, and agency, which are covered under contract 2 or special contracts. So these are kind of a special contracts which we will be covering into our next other video, and we'll be understanding about all these term in detail. So now let us understand what are the key words that we can derive from this verification. Enacted 1st September 1872. So this is the very historical background of Indian Contract Act. Extend whole of India. So when it will be applicable across whole of the India. Original section 266. So originally we have 266 in total, which later was removed. Contracts 1, section 175, general principles. So general principles falls upon section 1 to 75. Then we have special contract, that indemnity and guarantee, that falls upon section 124 to 147. Then we have bailment and pledge under 148 to 181. Then we have agency 182 to 238. Then we have Sale of Goods Act from 76 to 122, which was repealed by Sale of Goods Act 1930. So this is the very basic definition regarding Indian Contract Act. Now let's move into the meaning of a contract. The word contract originates from the Latin term contractum, meaning drawn together. So it is very much important to remember from where we have derived the very word, where it is Latin or Greek or Roman. So the very word contract has been derived from the Latin term, that is contractum, and which meaning is to drawn together. So when you are preparing a particular answer on contract, if you can add from where we can derive, so that gives the probability to score good marks in exams. So we need to remember from where we have derived that exact term. A contract is a lawful agreement between two or more persons for consideration. So what it says, a contract is a lawful agreement between two or more persons for consideration. So in order to make a contract, there has to be at least two party or more than two party, then only it will make a valid contract. For example, if A agrees to sell his house to B for 50,000 and B agrees to buy it, is a valid contract is formed. For example, A selling his house to B in 50,000 and B agrees that okay, I'll take your house and I'll pay you 50,000. So this is a contract because they have a written document and it is enforceable by law. Here A is the promisor. So in the Indian Contract Act, A become the promisor. A promises to B that okay, I will sell my house to you. And B is the promisee, is the acceptor. So B is the promisee here. It means B have accepted his proposal that He will be getting the house of A. So that makes him an acceptor or promisee in the language of Indian Contract Act. This agreement becomes a contract because it is legally enforceable, because buying and selling a house is a legally enforceable contract. Therefore, it makes a valid contract. Legal agreement between two or more parties. This is the very definition of or meaning of what is contract. Example, A agrees to sell house to B for 50,000. There is a promise, there is a promisee. So it makes a valid contract. A promiser, B promises. So after this, what makes these two person? A becomes promiser, B becomes promisee. Now let's move into enforceability of contract. A contract is said to be enforceable when one party has the legal right to compel the other party to perform their contractual obligation. If either party fails, the aggrieved party can file a suit for breach of contract. So this is the very enforceability. Now we will understand from the very example that we have given in a previous slide. If A refuses to sell the house after agreeing, B can go to court and vice versa. A said to B that okay, I'll sell my house. In case A changes his mind, B has the right to go to court and ask for remedy. So this is the enforceability of contract. If it's legal and binding, A cannot just change his mind all of a sudden. B has the right to go to court and seek for remedies. Enforceability, legal obligation. It's a legal obligation to A. A has the duty to perform his part of duty. Court can enforce performance of promise. So the court can declare that A has to perform his part of duty. If terms are breached, legal remedy. If A, you know, decides to not sell his house, so what can B do in such manner? The legal remedy that is available to B is A refuses to sell, B can sue. B can file a case against A for breaching the contract. So this is how contracts enforceability of contracts is made in India. Now let's move into what is contract of guarantee. Three parties. Unlike ordinary contract involving two parties, a contract of guarantee involves three distinct parties. So contract of guarantee, maximum three parties has to be there. And what are the person? That is the principal debtor is the one who owes the obligation. Then we have the creditor who is owned, and we have the guarantor of surety who promises to discharge the obligation if the principal debtor fails. So this is the very three parties that falls under contract of guarantee. This is a specific type of contract defined in the Indian Contract Act. So Indian Contract Act also defines contract of guarantee, which has to, made of three parties maximum. In case the party fails, the guarantor will come at that place. Now let us understand the keywords. Involve three parties, that is principal, debtor, creditor, guarantor or surety. Guarantor steps in if debtor defaults. So guarantor stays there as a guarantee to the other parties. Defined in section 126 to 147. So up to 126 to 147 defines what is a contract of guarantee, the parties, the essential, all kind of stuff has been defined under 126 to 147 of Indian Contract Act. Now let's move into legal definition of contract under Indian Contract Act. So now what we have understood, that was a historical term from where we have derived the very word, and in normal language what is this contract is made of. So now we will be understanding what Indian contract says about what contract is. Section 2H of the Indian Contract Act defines a contract as agreement enforceable by law. So this is the very definition given under section 2H. So we need to remember this very section at any cost, and also this very definition given under Indian Contract Act. This means that an agreement must not only exist but must also have legal backing. An agreement is formed when there is a valid offer and acceptance. So agreement is made when there is a valid offer and acceptance. Once this agreement is legally enforceable, it becomes a contract. So what makes a contract? That is offer and accepted. It has to be a offer from A. For example, A has offered his house, B has accepted his proposal. So there is offer and acceptance, and that makes a contract. Now let us understand the key points. Section 2H defines agreement enforceable by law is contract. What makes a contract? Agreement plus legal enforceability. And what makes an agreement? Offer plus acceptance. If there is an offer and there is an acceptance, that makes a contract. Example, oral promise with enforceability contract. It can be in oral form also. That also makes a contract. Now let's move into what is an agreement. Section 2E of the Act defines agreement as every promise and every set of promises forming the consideration for each other because they have mutually talked about offering something and the other person accepted in that also makes an agreement. It is a mutual understanding between two or more parties where one party makes an offer and the other accepts it. So here also offer and acceptance has to be there. It may or may not be legally enforceable, but all agreements are not contract. They are not enforceable by law. Points to remember, Section 2E, every promise and set of promises makes an agreement. Agreement offer plus acceptance, same with contract, may or may not be enforceable. Just because it made out of mutual understanding, it may be enforceable or it may not be enforceable. Contracts equal agreement plus legal backing. So what is missing in agreement? It is legal backing. Agreement is may or may not be enforceable by law, but in contract it is enforceable by law at any cost, and the person has the remedy to sue the other person who failed to fulfill his promise. Now let's move into what is the distinction between agreement and contract. Definition given under section 2E, given under 2H. Legal status may or may not be enforceable, always enforceable. So this is the very differences that sets apart agreement and contract. Origin arises from mutual contract, arises from enforceable agreement. Nature may or may be moral or social, always legal and binding. So contracts are always legal and binding. The person, at any cost has to fulfill his promise. If he doesn't do so, the other party has the right to sue him in the court. Whereas in agreement, if the party fails to perform his duty, the other party does not have the right to seek remedies in the court. Relationship, every contract starts as an agreement. So before entering into a contract, what is the first step necessary? That is agreement. There has to be an agreement in order to make a contract. You cannot directly move into the contract. There has to be an agreement between the parties. Not every agreement becomes a contract, but if we just agreed and there is no contract made, that will be only stick to that agreement part only. We will be not moving to the next step, that is making a contract. Now let us understand it in a more depth. While all contracts are agreements, not all agreements are contracts because the enforceability, there's all the kind of things that sets apart agreement and contract. So this is the very answer that I have asked in the very beginning of the video itself, and I hope it gets clear. If not, you can ask your queries in the comment section. I'll try my best to solve the queries. An agreement becomes a contract only when it is enforceable by law. If there is no enforceability, that is an agreement, that is not a contract. Agreements may be informal or social and lack legal force. Agreement doesn't have legal, legal force. A contract, on the other hand, is always legal, formal, and enforceable. On the other hand, the contract is always binding, formal, and enforceable. So this is all about distinction between a contract and an agreement. In this video, I have tried to make clear all the kind of necessary information relating to Indian Contract Act, and I'll be covering other part in my other lectures as well. If you find this video worth watching and if you have queries relating to the topic or you want me to cover such other relating stuff, you can write down your comments. I can get to reach it to you and offer my best explanation. So that's all for today. Thank you for watching the video.